Commissioner Indu Thomas presiding.
You may be seated. So I'm going to admit everyone. I'm coming in today. This is Commissioner Thomas. I'm coming in just to cover 4 of the matters. I'm not covering the 10 o'clock calendar. If you'll give me just a moment. Is this the one?
Yes. If you have it. I hope I fix that. Let's do it.
Okay. I'm going to ask everyone to stop their videos, except those parties who are on the Smith, Wells, and Smith cases. And give me just a moment to get things organized here. Okay. And do we have people present in person as well? Is Brecken Scott is present for petitioners Hans and Kathryn Stoker?
Yes, ma'am.
And are Hans and Kathryn Stoker present?
I'm not. Oh, Hans is. I see he's on Zoom. At least Hans is.
So could I have parties that are not on this case, please stop your videos, and let's have the parties that are on this case to start their videos. So is Justin Lang on this case? And you said that you saw Hans Stoker. Is he signed on as his name?
Yeah, I see somebody signed on as Hans, but he may there. I see he unmuted.
Yes, sir. Yes, Your Honor, I'm here. I'm
okay.
Just leaving it on mute to observe.
That is fine. Ms. Scott will speak for you. Give me just a moment. I'm coming in behind another judicial officer, and I just need to get the judge's edition open so I can pull up my notes.
My wife is here too. Kat, can you?
Thank you. Okay, so petitioners are present. Is Selena Smith present?
Yes, I am, Your Honor.
Thank you.
I think you're here.
Yeah, I'm here.
Kathryn's also here. Kathryn's just confirmed her attendance with me.
Thank you.
I'm going to mute myself because I don't want to have any background noise like barking dogs or crying babies.
I appreciate that. Thank you very much.
I'm going to mute myself right now.
Yes, please. Thank you. All right. And is Jim Wells present?
I'm here, Your Honor.
Okay, so you are signed on as Roddy Talk. I'm just going to rename you so that I don't lose you. Is Robert Ayers present? Robert Ayers? Okay. And John Smith is present. And is John Smith present in person or on?
I'm present, Your Honor, and I do have a comment before the proceedings go further, an objection to raise.
Understood. But I see that you filed a number of pleadings, and some of them actually indicate that Selena Smith is the declarant, but you signed them, and I am concerned.
That was a mistake, but I did review them, and yes.
Okay, so I'm going to have to strike what is identified in the court file as index number 64, as that is purportedly the statement of Selena Smith, but it's signed by John Smith, and I don't believe that John Smith is counsel, unless I'm missing something. I don't see a bar number.
No, it's
Your Honor, may I give an explanation?
a technical error where
I can clarify what the problem is.
So I think we just lost Selena Smith.
Your Honor,
And I am actually directing my questions to John Smith
thank you.
at the moment. So can we let him answer? Mr. Smith, am I missing something? Is there a bar number that should be associated with that?
Your Honor, I'm not an attorney. I'm my daughter's father, of course. My daughter has no
I
computer.
am not getting a response from Mr. Smith at this time, and I am going to strike
Well, wait.
index number.
I'm speaking. Can anybody hear me? Hello?
I am going to strike that matter, that document. So index number 64.
Hello?
I see from Ms. Smith's documents that she has an objection to jurisdiction, so I'll start there. So Ms. Smith, let me hear from you as to which state has proper jurisdiction.
well, we've been out of the state of Washington for since the end of November. Furthermore, there is a parenting plan
Can
out of
anybody hear me?
Colorado. Colorado has jurisdiction. Yes, we can.
Well, I'm sorry, I couldn't get through. That's when I was being addressed earlier.
Okay, I can't have you both talking at the same time.
Okay, go.
So, Mr. Smith,
I'll wait.
okay. But let's just close that loop. Mr. Smith, will you tell me if you are an attorney, and if so, what is your bar number?
I'm not an attorney, but I am acting as my daughter's scribe. She has no way to write or print up anything, and so I made a scrivener's error, and I apologize for that. And I do have an objection about the proceedings right now.
Okay, I understand that you have an objection, but I haven't addressed your motion, so you don't have standing.
I'm asking to join this. I filed a motion to
Understood.
join.
So first, I'm taking up the issue of jurisdiction, and until I take up the motion to intervene, you're not a party, so you don't get to speak. I did want to clarify whether you were counsel for Ms. Smith or just here as her.
I am her secretary, and so I was doing the best I can for her because she doesn't have any way to print. She doesn't have a computer. She has no way to print and submit anything to the court.
Thank you. Would you mute yourself and allow your daughter to speak, please? Thank you.
Thank you.
Ms. Smith, please clarify your argument on jurisdiction. Please go ahead. Would you unmute Ms. Smith?
Yes, I'm having some connectivity issues. I'm not sure why.
Okay.
Sorry.
If you can get closer to your router, that would make it easier. If you're able to plug in, then you'll have a nice stable connection. But if you can't plug in, get as close to your router as possible.
Yeah, I'm taking a break from my delivery job. I'm in my car and I'm forced to use my cell phone. So I'm doing
Okay.
the best I can.
Okay, go ahead with your argument. Your position is that Washington doesn't have jurisdiction, so tell me why that is.
Yeah, Colorado still has jurisdiction in terms of a parenting plan issued by that court between Robert Eyre and myself. Also, I've been out of the state of Washington for over 6 months, and we settled in Portland, Oregon.
Okay, and how long have you been in Oregon? How long have you been in Oregon, Ms. Smith?
Yeah, I'm really sorry. I'm doing my best here. I've been out of the state of Washington since the end of November, and I've been in Portland since January.
Okay. And are there any cases in Oregon?
No.
And are there any cases in New Jersey?
No.
And do either you or Mr. Iyer still live in Colorado?
I'm sorry, please repeat that. I'm really doing my best.
Does Mr. Iyer still live in Colorado?
Yes.
Okay. Ms. Scott, your response on the issue of jurisdiction. And Ms. Rivera, would you please stop your video? You're not on this case. Thank you.
Thank you. Your Honor, as a preliminary matter, that's news to me that Ms. Smith knows that that Mr. Ayers is in Colorado, because we've been attempting to get information from Ms. Smith about Robert Ayers so our skip tracer can find him and have him properly notified for this. Up until just now, my understanding was Ms. Smith had absolutely no idea where Mr. Ayers is. Our position as to case number 443, as it deals with Hazel, is that it's because we don't know whether Mr. Ayers is ill in Colorado or not. We have exercised efforts to locate him, to get his information. Ms. Smith had indicated at the last hearing that she had some information. Subsequently, she denied having access to that information to our office. She did provide some Facebook information, I think just a day or two ago, that we are following up on. Our position is that it very well may be that there needs to be a UCCJEA conference in regards to Hazel, because we don't know if Robert Ayers is still in Colorado or not. Certainly, if both parents were already out of the state, that would resolve the issue. Nonetheless, even if Mr. Ayers is still in Colorado, that does not mean that that state should retain jurisdiction. In that case, we would have a UCCJEA conference, and the courts would decide which court it makes more sense for the case to be heard in. My clients, we filed as part of Kat Stoker's June 15th, 2021 declaration. We provided a timeline going back to Hazel's birth in 2013, demonstrating that the children have resided in Washington and, frankly, with my clients for the majority of their lives. Ms. Smith left reportedly November, December 2020, but was transient, was not in any particular state. That's demonstrated by the evidence that's already in the record regarding her contacts with New Jersey, subsequently fleeing New Jersey to avoid child services oversight. She was temporarily in Oregon. We know she was in Washington as soon as March 3rd, 2021, because she returned back to my client's residence to pick up an RV, and they did overnight here in Washington in March. That's Miss Smith has not been in Oregon for 6 months preceding the filing of this petition. The children do not have any ties in Oregon. They are not enrolled in school there. They are not in daycare there. They do not have family there. The children's providers, healthcare providers, including Hazel's providers for her autism, are not located there. They are located here in Thurston County. Since the children have been back and placed with my clients, they have been finally taken to follow-up appointments for serious dental issues. Again, Hazel's autism. So our position is that Washington if there is no state that has jurisdiction, home state jurisdiction, so as to the two youngest ones, there is no order in place for that case. The kids have absolutely the most ties to Washington, and no other state can claim home state jurisdiction. So for those reasons, and on an emergency basis, the children are now located in Washington state. If there wasn't an issue with Oregon jurisdiction, then Ms. Smith should file something in Oregon, and we can have a UCCJEA conference about it. But this case needs to move forward. We need to get Mr. Ayers served. We need to get an evaluation done for Ms. Smith if she's going to contest this guardianship, and it needs to move forward on its merits and substance.
Thank you. Mr. Wells, did you have a position on whether Washington has jurisdiction?
Yes, Your Honor. I have an open parenting plan case in Thurston County.
Oh, okay.
And do you have a case number for that?
One moment, please.
Oh, and I would also note that the parent, the other parent of the children, Mr. Wells, is located in Washington State.
I believe the case number is 20-2-30788-34.
Actually, I'm familiar with that case number. That's the DVPO. Do you have a family law?
That's the other case number for the
Yes.
ridiculous DV charges. Another minute. I'm sure I have it.
Oh, you accidentally hit mute there. Could parties that are coming in for their other hearings please come in with your video off? Thank you.
1 minute, please. I'm going to look it up. I have it somewhere on my computer.
Understood.
Is that the kids?
I thought you
Oh, baby.
Yeah.
That's not fair.
It's not.
That's so mean.
Ms. Smith, would you mute yourself? Your comments are coming through on the record. Ms. Sisson, would you please stop your video? Thank you. And Mr. Wells, don't worry about it. I will take a look on the issue of jurisdiction. I'm reading between the lines. It sounds like you're saying that it should be here in Thurston County. You have muted yourself somehow. Would you unmute, please? Let's see. I send you an invitation. Okay, there we go. Go ahead. Is your position that it should be here in Thurston County, at least as to your two children?
Regarding my two children, absolutely yes. They have a large family support group in the area. The only persons who object to the children staying here are the paternal grandfather and the mother.
Thank you. And Ms. Smith, anything further on the issue of jurisdiction?
Yes, I do have something to say. It is not, the lawyer is misrepresenting the facts. It is not illegal to travel with my children. We were staying in domestic violence shelters. We settled in Portland. We have a home. I have a social worker, a paraeducator, a youth specialist for Hazel. She is enrolled for next year in an elementary school in our neighborhood, and we're working with that. Sorry, we've been working with that school to finish her schooling. I am not mentally ill. It's a huge inconvenience for it to be in Thurston County. Really, this is where we reside and where we have been residing. It makes the most sense for the kids and myself. This is our community and represents our people. It really, and there's every reason why it should be, why I believe jurisdiction should be here in Oregon, in Portland, Oregon.
Thank you. I have listened carefully, and of course, jurisdiction is the first issue that I must take up because I can't take up any of the other requests if we don't have jurisdiction. But clearly, as to RGS, actually, the children's names are RGS and OKSW. those two children, Thurston County or Washington has original and continuing jurisdiction. There's no action in any other state, and Mr. Wells continues to reside here. So jurisdiction is properly in Washington state. With respect to HS, that is a little less clear. So with respect to docket number 5, Colorado has original and potentially continuing jurisdiction, but because the father has not been located or served, we're not able to make that determination. I do see a copy of the Colorado order, and I am going to stay these proceedings in order to allow, frankly, service on Mr. Iyer and a UCC JEA conference to take place with respect to Hazel. In the meantime, it is appropriate for me to take up the issue as to whether temporary orders should continue as entered, or if we should resume the provisions of the Colorado parenting plan that was entered on October 4th, 2016. There's also Mr. Smith's request to join. It's appropriate for me to take that up today and not postpone that because the court does have jurisdiction on 2 out of 3 of these cases. I should say there's actually 2 cases, 3 children. It just appears on the calendar 3 times because of the multiple motions. So with respect to jurisdiction, I'm staying that issue until the court can have a conference with the court in Colorado. With respect to dockets, the case of RSW and OSW, the court is asserting jurisdiction because we have original and continuing jurisdiction, and the father continues to reside in Thurston County. And there is no other jurisdiction. There's no case in any other jurisdiction for the courts to decline jurisdiction to. And it appears that most of the evidence is here in Thurston County, as Ms. Smith was gone from Washington in November of 2020, resided in New Jersey, and now resides in Portland, and has not lived for 6 continuous months in any other location other than Washington, based on the written.
I never resided in New Jersey.
Turning to Mr. Smith's motion, I'll start with Mr. Smith.
Thank you, Your Honor. I do have some preliminary matters to raise.
Okay.
You have been involved with me before, and while recusals are discretionary, I at least need to bring this to your attention. Back about in 2010 or so, I believe it was, 2011, I was trying to accommodate a woman that was handicapped. She had a brain injury, and she had a case before you regarding emancipation of her adopted daughter. I was harassed and kicked out of that courthouse because I was accommodating this handicapped woman, and she couldn't remember what you had told her or said 5 minutes previously. You were aware of this fact, and you condoned the fact that I'd been kicked out of the courthouse, and you refused to appoint an attorney for the woman. So, and she requested that twice. So I believe that your bias in this case regarding at least me needs to be weighed, and I'm not certain that I can receive a fair hearing before you.
Okay. Well, Mr. Smith, I did not recall that case from 2011. That was 10 years ago. I like to tell people I meet 50 new people every week in this job. That's one of the detriments and the benefits of this job. I used to be good at remembering names before I took the bench 14 years ago. I simply don't any longer because I just do so many cases and meet so many people. So I don't believe that I have any bias. And if doing my job was a basis for bias, then clearly I would not be able to continue doing my job. So under the Code of Judicial Conduct, I must hear this case. So it is on my rotation. I do not have any independent recollection of you, and will make my decision today based on the written materials. The rule for intervention is Civil Rule 24, so I'll ask you to address how you meet the parameters and whether this is an intervention as of right or permissive intervention. Go ahead.
Well, I would request that either one would, yeah, I think it's a matter of right. I have an ongoing relationship with my grandchildren that, given the animosity between the Stokers and myself, they're utterly unaware of, and I've done that over the years by maintaining my relationship with their mother, Selena. I know her a great deal about her, and have repeatedly tried to stay in touch with my children. I mean, my grandchildren, Selena's children, since they were seized in Oregon at midnight, under cover of darkness, with no due process down there. Anyway, and I believe that there'd be harm through the parental alienation that is continuing, has gone on for decades, and is now affecting my grandchildren. And I want to see them. I care about them. I was there, when Raven was born. I'm aware of the father. I've met him. This entire proceeding is really affecting my grandchildren. I do object to the Stokers putting those children, making noise, into this proceeding. I think that's they should be sanctioned for that. It's pretty manipulative, and I'm the only person that refuses to choose between my grandchildren and my daughter. I'm not going to choose between them. I love them both, and I think that I can be benefit my grandchildren a great deal by explaining to them why their mother is absent, and where she is, and what she's doing, things that that the Stokers are not going to do. And I want to throughout this, whether they get guardianship permanently or whatever, I'm here to seek a visitation with my grandchildren at least once a month, and maybe more often, maybe a phone visit. And I've not been provided with that, and I've asked as much, and the Stokers have not accommodated me. I've had long discussions with their attorney, and I've been able to work with her, and I don't believe that she opposes I don't believe that the Stoker's attorney opposes my request to be joined to this action, and I'm frankly here to maintain my relationship with my grandchildren and my daughter, and to protect all of them as best I can, and that's important. And I don't believe that my daughter is in a position right now to be able to defend her rights as a parent adequately. I can't speak for her. I think she needs an attorney. I hope this court will appoint one for her right away, like today. And in the meantime, I want to maintain the ongoing relationship with my grandchildren. I feel that's in their best interest, and I think it may be a matter of right. And if it's not, I think that if it's discretionary, I think the court should just not try to reunify the families, not tear them apart. And this is destroying the family. This whole action is destroying the family. I want to do everything I can to maintain a relationship with my grandchildren and my daughter. Thank you.
Thank you. A couple of questions, Mr. Smith. Have you ever had custody of your grandchildren?
I have no reason to seek custody of them because my daughter is parenting them and doing a fine job of it.
Okay, thank you. Mr. Wells, your position on Mr. Smith intervening in this case? Would you unmute, please? Thank you.
Yes, Your Honor. I have read over the declarations filed by Mr. Smith, and apparently he bears a great deal of ill will towards me. He has succumbed to his daughter's lies about me. She consistently tells lies about me to all her family members, and everybody believes these terrible things about my character that cannot be proven and aren't even close to factual.
Thank you. Ms. Scott, your position on Mr. Smith's intervention?
Thank you, Your Honor. And I want to make it clear first to Mr. Smith that when I communicate positions to him or what we're willing to do, it is my clients also. I do not communicate positions that I don't think my clients, I've either already talked to them or think that they will agree with. So when my clients and I take the position that we don't, as a matter of, we don't strongly object. We kind of take no position. The way I read the statute, for who has a right to file a petition in the first place. It's pretty broad. Anybody who has an interest in the welfare of a minor. And I originally took the position with Mr. Smith, and in this case, that Mr. Smith is asserting that he has an interest in the welfare of a minor. Who am I to say that he doesn't? Upon rereading the general rule about, the rule about intervention, I'm not certain that it's appropriate or that it is a matter of right. I do at this point still want to leave it in the court's discretion. However, frankly, given Mr. Smith's recent conduct in writing emails inappropriately to the court, which are in the court's file, and then retaliating with communication again to the court when being admonished about ex parte communications, emails that he has sent threatening to sue my clients for $11.5 million or encouraging Selena to do so based on this. His attempts where he has triangulated the parties, where he has called up, or Selena has called up to talk to the children, and my clients have allowed that. And then all of a sudden she's patched Mr. Smith in on the call, and they are harassing and trying to trap my clients in a lie.
I'm going to object here. That this person has not been put under oath. She's testifying, not argument, and I'd like to respond to it when given the opportunity.
I'm actually going to sustain the objection. The statements of Ms. Scott are not supported by sworn testimony, and I will not consider them.
Thank you. Your Honor, I would like the court to consider the record, though, and the communications that had been filed in the court record, the declarations, and also just the content and the demeanor and context of Mr. Smith's own declarations. I have substantial concerns that if the court does grant his motion, that additional protective measures be granted. For example, if Mr. Smith wants to be a party to this action, I will ask the court order that all communications go through counsel and that he no longer attempt to contact my clients directly, that he no longer attempt to secretly call in on three-way calls with Selena, for example.
Objection.
Objection.
Mr. Smith, Ms. Smith, the objections are with respect to evidentiary issues. When you disagree, you just need to wait a moment until it's your turn to talk.
It is evident.
So ask both to mute, and I will give you an opportunity in just a second. Ms. Scott, is it still your position that you're not taking a position on the motion to intervene?
Yes, we are not taking a position, but we request that if it's granted, that some of the protective measures I just requested are entered.
Thank you. Ms. Smith, let me hear from you on your position as to whether Mr. Smith should be permitted to intervene.
He should be permitted to intervene.
Ms. Smith, we've lost you again.
He's had a strong interest in relationship with the children for years now, and he's a very good friend.
Thank you. Mr. Smith, you get the final word.
Yes, I'm going to object to the Stoker's attorney trying to persuade the court to punish me for the communications that I've had, and if I might be permitted to clarify, because what she paints with a very broad brush. The communication that I had with Shelley Brandt through her personal private email, I wanted to notify her that that she could not preside in this case because she has heavy engagement and entanglement with all the Stokers. She's represented my ex-wife in the past. Okay, I won't be too lengthy about this, but this is relevant. She's represented my daughter. The Stokers have paid her, and Mr. Cortacray recused himself in this matter because he recognized that he had or remembered that he had knew the declarants and couldn't in good conscience preside because there was a conflict of interest. Yet he already had issued orders, and yet with this conflict of interest. So I wanted to make sure that we didn't have a repeat of that, and that Shelley Brandt, started making rulings, without being aware that or claiming that she was unaware that there was a conflict of interest. So that's true. And then I have included Miss Brecken Scott. I've tried to be as collegial as possible, and she's doing the best job that she is, capable of, trying to represent her clients. But we both agreed that the grandchildren should be considered very carefully. And I wrote her a letter. The first letter before I'd ever spoken to her was disparaging. Okay, I was kind of insulting to her, and she sent a copy of that to Kathryn Stoker, who called me on the phone and was screaming at me that I had insulted her and that I had insulted the attorney. And I said, well, look, tell your attorney not to feel special. I insult a lot of attorneys. That goes with the territory. And as far as the court...
Mr. Smith, I'm going to interrupt and ask you if you'll just make the final words about your motion to intervene.
Okay.
Because you're...
But I'm challenging what Ms. Scott has said, and it's inaccurate, and she's got a habit of exaggerating what it is that she relies on. So my case for intervening is that I have an ongoing relationship that I need protected, and the Stokers and Mr. James Wells, who I know a great deal about, are hostile to that. And frankly, I have not always been easy on my daughter either. I mean, out of regard for my children, but she respects that, and the Stokers and Mr. Wells do not. And so it's very necessary for me to continue to maintain the relationship, and I do object to the Stokers putting the children's voices into this proceeding. I think that's my daughter objected. She said that's unfair. It is very unfair, and it's typical. Thank you.
Thank you. I'm going to ask you to go ahead.
Don't talk, Hans. Hans, stop.
I'm going to ask you all to mute yourselves so that you are not talking over the court inappropriately, including the Stokers.
If allowed.
No, you've hired counsel to speak for you, and she has spoken for you, and that there are other matters on the calendar this morning. I'm going to go ahead and mute the parties. Thank you. So with respect to the motion to intervene, that is covered at Civil Rule 24, and there is intervention as of right, and there's permissive intervention. Given the broad nature of the statute, I am evaluating this under intervention as of right. Mr. Smith is a grandfather, and the statute confers rights to intervene. However, the rule also requires me to look at whether it's not an unconditional right, it's a conditional right. And here, Mr. Smith is not asserting a claim to custody. He is joining simply to support his daughter, Selena Smith, in seeking custody of her children. And she is able to represent her interests in this matter. So I am denying the motion to intervene on that basis. I see that Mr. Smith has unmuted, but I'm going to ask him to remute himself. In this type of action, an emergency action, there is not the right to counsel. The right to counsel is in a regular action. An emergency action can only result in a 60-day grant of custody, which can be extended for an additional 60 days, and there is no right to counsel. However, if a regular guardianship is filed and there is a request for counsel, then the court would have to review financial documents to see if parties are indigent and entitled to counsel at county expense. So I would direct Mr. Wells and Ms. Smith to make those requests and file the financial declarations with the court if a regular guardianship is filed. And from my review of the paperwork, it seems that the intent is to move in that direction. So for today, I'm staying the matter as to HS, pending a UCC JEA conference with Colorado. I'm denying Mr. Smith's motion to intervene. And there are some I's to dot and T's to cross. I am not seeing proof of service in these documents. As to the parents,
Your Honor, there should be an acceptance of service as to Mr. Wells. We filed his acceptance of service in, was it 21400452-34. And we were requesting, and I can file it on the ex parte calendar if I need to, but I would like permission to serve Mr. Ayers by publication in Boulder County, which is in Colorado, which is the last county where we knew he was.
I have a number of motions before me today, but that's not one of them. So I'll ask you to prepare it and file it, following the proper procedure. And Ms. Smith, how did you know to be present? And we are struggling still with Ms. Smith's access.
Sorry. My apologies. I knew.
I'm so sorry. I'm just not able to hear Ms. Smith at all. So the final thing that I'm going to do today is just continue this. I am going to ask Ms. Smith to make sure that you are at a hotspot or someplace with really strong Wi-Fi, or that you are plugged in. I'm not requiring you to come to Washington when you're in Portland, but if you're not able to get a better signal for your own procedural well-being, I'm going to ask you to make sure that you're calling in so that you have a nice, strong signal and I'm able to hear you. I am going to... because Commissioner Corder-Cray has recused, I have to set this on one of my calendars. And I'm going to extend the underlying orders.
I can't respond. Oh, no.
Well, you know, everyone else in the courtroom is feeling like I have spent an inordinate amount of time listening to all of you respond.
Yeah, but I never
I'm
get a
struggling
chance.
to hear you.
I never get a chance to speak because
So I have one slot left on July 6th. I'm going to direct Ms. Scott to correct the file. And I'm going to set this over to July 6th, which is a very short continuance. And I'm going to direct Ms. Smith to make sure that she is in a location where there's a solid signal, or that she's just calling in from a landline, so that we don't have what we had today, which is really, to me, it's not justice if I can't hear you completely. I've read all your materials, but I want you to be able to hear everything that everyone says, as well as to also be able to move forward. And we have some flaws today. So can I get an order setting? So we've done 2 out of 3,
Right.
and
I'm going to object to the ruling and, for the record, and I'm giving notice now that I've been seeking review of it.
Your notice, your objection is noted. I appreciate that. Thank you.
You want me to respond about service? I can't answer that question.
Go ahead. We'll see if you stay there. But did you hear? Are you available on the 6th at 9?
Yes, I will do my best. This interferes with work, but yes.
And Your Honor, I'm sorry if I'm just being dense this morning, but what did you mean by give me a chance to correct the file? Are you talking about filing
service documents
for some of the service issues?
Yes.
Can I speak?
Okay.
I never get to speak.
Go ahead.
All right. So I knew because after they seized the children, and I came straight to the Thurston County Courthouse and I asked for all the legal documents, and I called them. Yeah, my connectivity is bad. My apologies. I do want to be able to answer all your questions and address these matters, but I do need the phone number and I do need this information. And I want to be, I do feel that I've been unable to be heard. Everyone else talks and it's very voluminous, you know, and I would like the chance to be heard.
Okay. I feel like I have heard from you on each of the motions that I addressed today. I am going to continue this on a really short time frame to Tuesday, July 6th, so that we can hear from you fully on the most important issue is where the children should reside. Because unfortunately, I am not hearing you at all. You are cutting in and out.
Yes. I would like to very much to be heard on where the children should reside and to clear up the misrepresentations. It's not true that
so again, Ms. Smith cutting in and out is just, to me, further evidence that we really need to set this over until she's able to find a location where she can participate more fully. So we will try this again on the 21st. The underlying orders will be extended to that time. Sorry, the 6th. Sorry, I said 21 because I wrote the case number. Sorry about that.
It's all right. In the meantime, I'll get the regular petitions filed. So perhaps the court may consider appointing her counsel on that date as well. I agree that since we are moving that direction, that it would help and facilitate everything if Ms. Smith had appointed counsel.
I am able to speak on my own behalf, and I do need a connection. Thank you, Your Honor, very much for consideration. I look forward to the opportunity to be heard.
I'm so sorry. I'm having difficulty hearing you. I did hear you say that you need a connection. I am going to extend the underlying orders for a brief period of time to July 6th, where hopefully we can address that issue with you having a solid connection. I will enter a stay order on the matter of HS until we're able to set up a jurisdictional conference with Colorado, and I will address where the children reside pending that UCCJEA conference on HS, where I'll address all 3 children on July 6th. In the meantime, they'll continue to reside with the Stokers as indicated in prior orders. Thank you.
Thank you, Your Honor.
And I'm going to excuse everyone on the Smith matters, and I will be at recess so that the calendar can return to other matters heard by Commissioner Brandt.
All right. Court is now in session. Commissioner Indu Thomas presiding.
You may be seated. So I'm going to admit everyone. I'm coming in today. This is Commissioner Thomas. I'm coming in just to cover 4 of the matters. I'm not covering the 10 o'clock calendar. If you'll give me just a moment.
Is this the number? Yes. We do have 54569. There's 2 for it.
Okay. So I'm going to ask everyone to stop their videos.